我哋係啦，我哋會開始係先影嘅相先嘅，佢哋會攞起個 report，咁大家就可以拍攝啦。
Okay. Closer. Oh, 冇所謂嘅。You want us to stand in the front?
Thank you. This way.
Turn a little bit. Yeah.
Okay.
Okay, camera. ，OK 啦。
OK， 好，唔該晒，仲有一張。係。好。
Wait. Thank you, sir. Madam, Thank you.
唔該晒。好，唔該晒。
Thank you.
多謝大家嚟到今日法律改革委員會發表與仲裁結果有關的收費架構報告書嘅記者會。咁首先等我介紹下今日記者會嘅講者啦。坐喺中間嘅係法律改革委員會轄下與仲裁結果有關的收費架構小組委員會聯合主席張清明女士 Miss Catherine Sanger。喺主席左手邊嘅係小組委員會喺主席右手邊嘅小組委員會成員陳澤明先生。喺另一邊主席嘅左手邊嘅係小組委員會另一位成員盧君正博士。而喺我旁邊呢一位咧係法律改革委員會嘅秘書長黃惠聰資深大律師。而喺另一邊咧係小組委員會嘅秘書馮淑芬女士嘅。咁我哋而家就先請主席咧介紹一下報告書嘅內容，之後咧我哋會再有答問環節㗎。May I invite our co-chair to give a brief introduction on the report, please?
Thank you, Olivier. Ladies and gentlemen, It's been a busy year, so it gives me great pleasure to present to you the final report of the long-named Law Reform Commission's outcome-related fee structures for arbitration subcommittee. Hong Kong law currently prevents lawyers from agreeing a fee agreement with their clients for a contentious matter where any part of the fee depends on the successful outcome of the case. In this respect, and this is important, Hong Kong is one of only 2 major seats for arbitration, the other being Singapore, that currently prohibits these types of success fees for arbitration. England, France, Switzerland, the United States, mainland China, all allow these fees in one form or another. And Singapore, which is the only other outlier, is expected to change its law and to permit these types of fees, at least in one form, in the near future. And the relevant bill went to the Parliament of Singapore on the 1st of November this year. Now, there is fierce competition amongst arbitration seats to attract users and stakeholders. It is also a priority of the Department of Justice and the wider Hong Kong disputes community to maintain and enhance Hong Kong's status as one of the world's top arbitration seats. It's currently ranked as as the top 3rd arbitration seats in the world. So this subcommittee was therefore given the task of reviewing the Hong Kong legal position to determine whether reform was needed for success fees, what we have called outcome-related fee structures for arbitration in Hong Kong, and to determine what recommendations to make that we consider to be appropriate, having done that review. Now, for those of you who were here this time last year, the subcommittee published the consultation report in December 2020, and the subcommittee unanimously concluded that the prohibitions on these types of outcome-related fee structures should be removed. And during the consultation period, which lasted until shortly before the middle of last year, we invited responses from all over Hong Kong to seek views on whether reform was needed. In total, we received 23 responses. We had responses from local law firms, from international law firms, from arbitration centres, including the Hong Kong International Arbitration Centre. We had responses from the Department of Justice and various regulatory and professional bodies, including, relevantly, the Insurance Authority, the Law Society, and I'm pleased to have Mr. C.M. Chan by my side representing the Law Society today, and also the Bar Association, and again we have Mr. Benny Lowe representing the Bar. And I'm very pleased to say that the responses were overwhelmingly supportive of the recommendations that we had made and of changing the law to allow for these types of outcome-related fees in arbitration. So after considering these responses and having done a detailed review of the legal position in the other major jurisdictions that seat arbitrations, the subcommittee has maintained its recommendations that the prohibitions on the use of outcome-related fee structures in arbitration should now be lifted, and lifted as quickly as possible. The responses show that this is very much what stakeholders and users of arbitration in Hong Kong want and in fact need. And critically, from the Hong Kong public perspective, this brings Hong Kong into line with other major arbitration seats. It allows Hong Kong to maintain its status as a leading arbitration seat. It allows us to be competitive, which benefits everybody in Hong Kong, and including the legal profession, but also the users of arbitration, because we are seeing that clients are demanding that we be permitted to allow these types of fees so that they can keep choosing to seat their arbitrations in Hong Kong. And in fact, given the rise in arbitrations involving mainland Chinese parties, including claims arising out of the Belt and Road Initiative, of which there are an increasing number in Hong Kong, it's important that we can charge legal fees on the same or a similar basis to our counterparts in mainland China, where these types of fees have been permitted and in fact have been working very well for some time now. So turning now to the final report, I'm afraid I've had no more success in keeping my mask above my nose than I did last year, but I hope you will bear with me. But for the purpose of the consultation exercise, outcome-related fee structures are agreements between a lawyer and a client where the lawyer receives a financial benefit if those proceedings are successful within the meaning of that agreement. And for those of you who've had time to go through the report, there are 3 types of outcome-related fee structures that we have recommended be permitted in Hong Kong. The first are what we call Conditional Fee Agreements, or CFAs, where lawyers charge benchmark fees or a discount to benchmark fees and an uplift on those fees if the case is successful. The second type are what we call damages-based agreements, or DBAs, and this is where the lawyer charges no fees through the lifetime of the arbitration, but takes a percentage of the financial benefit that the client obtains in that arbitration. And the last type is what we call a hybrid damages-based agreement. And these are agreements that are suited to long-running, complex, sophisticated commercial arbitrations where it would be difficult for a lawyer not to charge any fees at all through the lifetime of the dispute, that they are permitted to charge a discounted fee and then also to take a percentage share of the outcome once the arbitration has concluded. So in light of the overwhelming support from the responses we received, the final report recommends that all 3 types of outcome-related fee agreements be permitted for arbitration in Hong Kong and that the existing legal prohibitions be lifted. It's important to note that the recommendations are limited to arbitration and court proceedings related to arbitration, such as applications before the Hong Kong court to set aside an arbitration award or challenges to awards, etc. The scope of our consultation does not extend to other types of Hong Kong contentious proceedings. It does not extend to litigation, and it does not extend to mediation outside the 4 corners of the arbitration regime. The final report contains 14 recommendations. It includes draft legislative provisions that would implement the recommendations. You will find those at Annex 1 of the report. And that includes amendments to the Legal Practitioners Ordinance and a new Part 10B to the Arbitration Ordinance. And I would like to thank in particular the Lord Draftsman for working closely with us during a fairly intense period to pull this together, and I think it's a testament to the support that we have received from the Department of Justice in that regard. In Annex 2 you will see a list of regulatory safeguards that set out the content of what we propose should go into subsidiary legislation that deal with the safeguards that will protect not only users of these fee arrangements but also lawyers moving forward. And we have come up with this list by, again, looking at the regulatory position in other jurisdictions to see what has been working well and what is needed. And finally, for those that are interested, a list of the respondents is set out in the final report at Annex 3. The principal recommendations to lift the prohibitions you will find in recommendations 1, 4 and 10 respectively for CFAs, DBAs and hybrid DBAs, and it follows the same format as the consultation report that we issued last year. These changes, as I've said, will be implemented by amending first the Arbitration Ordinance, CAP 609, and second the Legal Practitioners Ordinance, CAP 159. We will also need to be, there'll also be to have amendments to the relevant codes of conduct, so the Hong Kong Solicitor's Guide to Professional Conduct and also the Bar Association Code of Conduct. You will find that in final recommendation 11, and as the Law Society and the Bar were supportive of the recommendations, then we would hope that those codes would be amended in time and in line with the relevant legislation. We have proposed, again, for the benefit of users and for the Hong Kong disputes community, that there be simple and clear regulation. We have proposed additional regulations, as I've said, to protect the interests of clients and also their lawyers who enter into these types of arrangements going forward. So, for example, we recommend that any agreement dealing with these types of outcome-related fee structures should be in writing, that they should state clearly when and in what circumstances the lawyer's fees and expenses should be payable. They should state clearly what is the definition of success and financial benefit, which we have recommended should be as broad as possible to meet demand and provide flexibility to clients. There will be a minimum cooling off period of 7 days, which actually is longer than many other jurisdictions which have 5 days, but we felt that that was an important safeguard for clients entering into these types of arrangements in case the client changes her mind. And the lawyer also has an obligation to inform the client of the need and the right, in fact, to take independent legal advice. And parties who have entered into these types of arrangements consistent with third-party funding will need to disclose that to the other parties to the arbitration and also to the arbitration tribunal or the court if it's a related court proceeding. And these regulations, as I have said, we think should be in subsidiary legislation. That gives them the force of law, so they are final and binding, which we think is important. But also, it means that if we would need to make changes to any of those safeguards, then they are in a more flexible format, so those changes can be made more easily. The majority of respondents agreed with this approach, and you will find this explained in more detail in final recommendations 8, 12 and 13. And then looking at caps, we talked about this last year, again in line with other jurisdictions that allow outcome-related fees, including in England and Wales and in mainland China. We also propose that the fee arrangements be subject to strict caps, and this will be contained in the subsidiary legislation. And this, we think, will protect clients and in particular promote public confidence in the success fee regime looking forward. For conditional fee agreements, CFAs, we recommend that the success fee be capped at 100% of the lawyer's what we call benchmark costs, and that is consistent with the position in England and Wales, and that barristers should be subject to the same cap. If you have any questions about barristers, of course you have Mr. Lowe that you can pose those questions to. For DBAs and hybrid DBAs, we have recommended that the DBA payment, which is the payment to the lawyer in response to the success in that arbitration, be capped at 50% of the financial benefit obtained by the client. And we have used the term financial benefit instead of the term damages to broaden the scope of cases in which clients can agree a DBA or a hybrid DBA, and that's really to benefit users, clients of arbitration. So, for example, a client is sued for 100 million Hong Kong dollars, then they can agree with their lawyer that if the lawyer successfully defends that claim and has a outcome where there are no damages payable, then the lawyer can benefit and be paid by the client accordingly, and that benefits the client as much as the lawyer. The majority of respondents who commented on these proposals, which you will find in recommendations 3, 7 and 13, agreed. They preferred the regime in Hong Kong to be as flexible as possible, and they agreed that lawyers and clients should be able to negotiate appropriate arrangements on a case-by-case basis, but subject to the overall cap. When we look at costs and fees charged during the arbitration, the subcommittee and the respondents overwhelmingly agreed again that where a party negotiates an outcome-related fee structure with its lawyer, that arrangement in general should have no impact on the other party to the arbitration because it's a private arrangement between the client and the lawyer. So where an outcome-related fee agreement is in place, we have recommended, and you will find this in final recommendations 2 and 5, that the portion of the lawyer's fee that is contingent on the success should not, in principle, be paid by the other party to the arbitration. And these follow the current English legislation. However, in the course of the consultation, a number of respondents pointed out that there may be situations where it would be fair and reasonable for the losing party to bear some or all of the total legal fees of running the arbitration, including the success fee element and or any insurance premium. And so you will see that we have recommended that where a success fee arrangement is in place, then a tribunal has power in exceptional circumstances to order the losing party to pay all or at least a portion of the success fee premium and any insurance premium that has been incurred and paid by the successful party in the arbitration. Finally, again, I think it's important to note that personal injury claims are one category of claims that have been excluded. Now, users of arbitration are generally sophisticated commercial, governmental or quasi-governmental parties. So in fact, there are very few pure personal injury claims which are arbitrated, or at least that we see. But during the consultation, a concern was raised that parties to personal injury claims may be more vulnerable, and so we have carved out personal injury claims of any nature from the scope of the reform, and you will find this in Annex 1 in the proposed amendments to the arbitration ordinance. But we have not recommended that any other category of claims be excluded, so long as it's an arbitration and related court or mediation proceedings that fall within the scope of the arbitration ordinance. And then the rulemaking power is also dealt with in the report. As I've mentioned, it's important for this regime to be effectively and fully regulated in Hong Kong, and this protects users of the regime as well as Hong Kong's reputation. I've mentioned the excellent drafting assistance by the Law Drafting Division of the Department of Justice, without which we would not have the amendments before you today. And the subcommittee set up a separate working group comprised of Dr. Benny Lowe to my left, and Ms. Brianna Young, who is my co-chair, and unfortunately is fortunately she's with her family in England, but unfortunately can't be with us at the press conference today. But she worked very closely with us in putting together the amendments to the legislation, and assisted by Ms. Kitty Fung and Wing Yi Ha of the DOJ, who all worked very hard in putting together the draft legislation in a very short period of time. And you'll see that relevant amendments to the Legal Practitioners Ordinance, as I've said, and the Arbitration Ordinance are found in Annex 1. The Law Society and the Bar will need to make changes, again, as I have said, to the relevant professional codes of conduct, and that's in Recommendation 11. In relation to the subsidiary legislation, and you will see this in the proposed amendments to the Arbitration Ordinance, the Secretary for Justice is empowered to appoint an advisory body, and this is similar to the third-party funding regime, but that advisory body will work to make the detailed rules, the subsidiary legislation, for the full implementation of the outcome-related fee structure, and that will bring into force the safeguards that you see in Annex 2 of the report. This will take the form, as I have said, of binding subsidiary legislation, and that will require the prior approval of the Chief Justice before those regulations will come into effect. And you will see this in recommendations 12, 13 and 14. So to conclude, I cannot overemphasize how pleased we are to be sitting with you here this side of 2021 to release the final report on outcome-related fee structures for arbitration. I would like to take this opportunity to thank my fellow co-members, Dr. Benny Lowe, CM Chan, Ms. Brianna Young in particular, and also Ms. Kitty Fong and Ms. Wingji Ha, who have been a fabulous team in putting this together, and we will be delighted to answer any questions that you have about the final report. Thank you.
Thank you, Miss Anne。咁我哋而家咧就嚟到呢一個答問嘅時間啦。咁如果大家有對報告書內容有問題咧，都歡迎提問嘅。係咪 now？ 係 now 嘅。
你話想問兩個問題嘅，第一咧就係即係今次嗰個修例建議咧，其實係咪正式即係確立咗即係以往禁止嘅即係包攬訴訟啊，或者係助訟啊，其實呢種原則咧就將會即係唔再適用㗎啦。以後其實呢種行為或者呢種係都合乎即係公眾利益嘅法律行為啦。咁另外第二個問題就係咧，即係人身傷害嘅申索案件咧，都係特別提到係唔包括喺今次修改之列嘅。最擔心係出現咩情況咧？或者係日後會唔會有機會其實連人身傷害申索嘅案件咧，都係納入埋嗰個修改之列咧？唔該。
我答第一個啦嚇，我諗重申翻一次頭先主席講啦，呢一次個報告書咧，我哋只係針對仲裁去講嘅啫，所以頭先呢位記者嘅問題咧，助訟同埋呢一個包攬訴訟咧，喺香港目前嘅法例之下仍然係禁止嘅。咁我哋今次個建議係純粹係將呢一個改革咧係圍繞住仲裁有關嘅啫，咁就同其他訴訟咧以至呢個mediation 咧都係冇關係嘅。Benny，
係唔該啊！咁啊，我想補充下第一點咧，其實我哋今次嘅修例建議嚟講咧，係為咗咧係去話特定咗，我哋係跟翻喺仲裁適用嘅按結果而釐定嘅一個嘅收費架構啦，係話係唔會係因為嗰啲助訟或者咧係包攬訴訟呢啲嘅刑事罪行同埋咧呢個嘅叫做呢啲嘅侵權嘅行為咧係會被影響嘅。即是話咧，換句話講啦，只要一個咁嘅收費協議係符合喺仲裁上面適用嘅，第一；第二就係話咧係符合我哋咧建議裡面所規定嘅每條嘅規例啦，喺我哋喺附屬嘅法律將會指出嘅要求啦。如果符合上所有呢啲條件嘅話咧，係就唔會被助訟同埋包攬訴訟呢啲嘅法律原則咧被影響嘅。咁所以咧就係話只要係符合晒所有嘢呢啲條件喺仲裁嘅框架裏面就冇問題。呢個第一個問題，第二個問題或者我嘗試答就係話關於呢個人身傷害嘅申索呢。首先呢個起點呢，我會想澄清一點呢，就係話人身傷害嘅申索嚟講，根本呢一般嚟講都係絕少咧用仲裁處理嘅。原因就係因為咧仲裁嘅前提咧就必須要有一份仲裁協議，即是話喺合約嘅雙方啦係訂立咗，如果發生咩爭議嘅時候咧，就會將個爭議咧訴諸仲裁處理，而唔去法院去處理。咁所以咧，如果我哋考慮到其實人身傷害嘅情況咧，譬如你行路俾架車撞到，根本咧你同埋嗰個司機之間咧，一般嚟講係唔會預先有一份嘅協議係話如果我俾你撞到嘅時候咧，會將個爭議咧訴諸仲裁。咁所以咧呢個本身嚟講咧，我哋都覺得係一個去仲裁一個人身傷害嘅申索咧，根本咧個現實嘅機會咧係比較低。呢個第一點。第二點嚟講咧，就係話咧但係咧，姑勿論咁都好啦。咁我哋喺我哋諮詢嘅過程當中咧，亦都有一啲嘅回應者咧係都提出咗一啲嘅擔心，因為傳統嚟講咧係喺人身傷害嘅情況嚟講咧我哋嘅英文有一個字就叫做 ambulance chaser。即係咧叫做咧救護車嘅追逐者啦，就即係意思就係話有一啲可能唔係好誠實嘅律師或者法律嘅從業人員，就去利用咧呢啲消費者或者一啲受傷嘅人士啦嘅一啲嘅無知啦，或者對法律嘅唔理解啦，咁咧由好容易咁樣咧就俾佢哋咧係去說服咗，去利用呢啲咁嘅包攬訴訟啊或者助訟啊呢啲咁嘅行為咧係去慫恿咗佢去開展一個法律程序。咁咧呢一樣嘢咧，我哋就都覺得呢個擔心咧係合理嘅。雖然喺人身傷害嘅申索上面咧，其實就絕少用仲裁，所以咧我哋喺今次嘅建議裏面咧，亦都係決定咧係將呢個人身傷害嘅申索咧係去排除喺呢個框架之外嚇。希望答到兩個問題，唔該。
下一位係香港電台，
係你好想請教下咧，就係都見到你哋提出咗有3種嘅收費模式啦，可唔可以用一啲淺白啲嘅字眼，可能同公眾解釋下其實佢哋係有啲咩分別啊咁樣咧？即係會唔會有一啲具體嘅例子可以講一講咧？咁另外咧都想請教下，即係都見到你哋訂立咗一啲保障措施啦，尤其是主席都提到冷靜期嗰度其實係比其他地區都多咗啲日子嘅。咁想請教下，即係嗰啲保障措施嗰方面，其實訂立出嚟其實係想防止發生啲咩呢？係點樣保障得到啲當事人咁呢？咁同埋都想問埋就係你哋即係可能期望政府嗰個落實呢啲修改法例呢啲嘅程序，即係具體個立法時間表，希望係可以幾時做到？唔該晒。
我係開個頭，跟住我俾阿 Benny 答啦。嗱，咁主席頭先提到啦，我哋而家建議咧係有3類嘅收費嘅。第一個咧就叫做按條件收費協議。第二個咧叫做損害賠償收費協議，第3類咧就叫混合式按損害賠償收費協議。咁頭先記者都提到啦，咁我哋個建議裏邊咧，呢3類嘅協議都好咧，我哋係有好多保障俾翻公眾人士嘅，包括最重要頭先提到嘅7天嘅冷靜期。而呢個7天冷靜期咧，係比其他嘅司法管轄區咧係更加對公眾有保障嘅。咁另外其他嘅建議，譬如一定係書面訂立啦，要好清楚去定明咩叫成功啦，呢一啲字眼我哋都要求喺個協議裏邊寫得好清楚。目的只有一個，都係要嚟保障公眾嘅利益嘅。Benny 你補充下。
好啊。我先答第一個問題啦。記者朋友就問有冇啲例子去解釋下嗰3種唔同嘅協議有啲咩分別。咁其實咧，我哋喺個報告裏面咧，喺個引言裏面第8頁咧，第1.7段咧，其實有少少例子嘅。不過我都而家去解釋少少。第一樣嘢咧就係話，第一個模式就叫做按條件收費。咁個條件嘅意思就係一般嚟講，雙方即係意思就律師同埋佢個客戶咧，就會同意喺嗰個協議上面就話，如果係有個成功結果嘅時候，個收費會有啲乜嘢唔同。咁當然一般嚟講咧，如果喺而家呢個情況，我哋呢個叫做 ORFS 嘅做法啦，咁一般個律師咧就會收一個有折扣嘅收費先，或者咧甚至乎咧係唔收費。咁但係咧，當達至咗呢個成功結果嘅時候咧，喺個仲裁裏面達到成功結果之後咧，咁佢個收費咧就會增加，而增加到嘅程度一般嚟講就會比佢嘅基準收費係會多啲嘅。嗱，如果唔係嘅話咧，咁就無法反映咗咧律師係去承擔呢個風險嘅情況啦。咁所以係作為一個補償，係俾嗰位律師咁樣做嘅。咁而呢個嘅成功嘅收費咧，個計算模式咧係用翻有2個情況，一個就係用一個定額，大家就 let's say 100蚊或者咩嘅金額都好，定一個定嘅額。如果成功咧，嗰個律師咧就可以額外得到呢一個定額嘅酬金嚇。第2個情況就係話咧，按翻個律師個基準個小時費率嚇，一般好多律師都係用按時去收費啦。咁譬如如果佢本身嗰個收費係假設係1000蚊1小時嘅。咁咧，但係咧，由於雙方同個客戶啦簽咗呢一個咁嘅按條件收費嘅協議，咁佢就同意咧，咁好啦，咁我就收500蚊1小時。但係咧，若果咧嗰個仲裁咧係達至成功之後咧，有個成功嘅結果啦，咁咧嗰個律師咧就可以得到咧唔止1000蚊啦，咧先得到1500蚊每1小時去計算。咁所以咧，其實咧嗰個律師咧最後尾如果成功嘅話，收費係多咗嘅，而呢個係反映而係個補償俾佢咧去同客戶一齊咧去承擔呢個仲裁嘅結果嘅風險。呢個就係個例子。咁至於第2個模式就係叫做按損害賠償收費咧，呢個咧其實咧理論上咧都係喺成功嘅情況之下，個律師咧係可以攞多啲嘅報酬嘅。咁但係嗰個報酬嘅計算方法咧，就我哋要用一個叫財務利益嘅概念。咩叫財務利益咧？就係話你可以係申索一個金額而討回到某個金額，呢個對個客人嚟講係一個財務利益，呢個其中一個例子。另外一個例子就係正如頭先主席咁講啦，如果你個客人係一個被告並唔係一個申索人，咁佢可以減少咗佢對嗰個原告人嘅法律責任嘅話咧，呢個對嗰個被告嚟講都係一個財務利益嚟嘅。咁咧，律師喺一個成功地幫個客人申索到啲金錢翻嚟，或者幫佢成功地減免呢個法律責任嘅情況之下呢，係可以得到一個額外嘅酬金。咁呢個酬金嘅計算辦法就唔係好似按條件收費咁樣啦，就唔會話用佢個小時費率啦，或者係一個定額，但係呢就會係呢按一個 呢個財務利益得到嘅一個百分比去計算。有一啲嘅以前嘅講法就係話你去變咗好似係收到個賠償，咁你個律師就可以攞一部分，就係呢個咁嘅概念，就簡單咁樣。咁我去到最後一個方式就叫混合式按損害賠償。咁啊例子就係咩呢？其實呢個呢，其實基本上係一個按損害賠償嘅收費。按損害賠償嘅收費有一個唔好之處，對個律師嚟講係咩呢？就係話當嗰個法律程序仲係進行緊嘅時候呢，好有可能呢，就係律師根本係唔會有一個收入啦，去到去保持住佢個現金流嘅。因為如果一啲嘅法律程序好複雜，係牽涉到可能數以幾年嘅時間先可以完成到嘅話呢，咁嘅話呢個律師呢就會係現金流可能會有問題。咁呢一個混合式嘅模式呢，就係去反映翻呢個情況，就係話你如果得到嗰個財務利益嘅時候，客人攞到，咁呢個律師可以亦都可以分翻一部分。但係咧喺進行法律程序嘅時間當中咧，佢仍然咧都可以收到一個打一個折扣嘅收費。咁所以呢個就係點解叫混合式模式，就係咁解，就係幫助一啲嘅情況，就係話個律師可能佢根本就如果要接呢單案嘅話咧，根本就冇辦法接到呢單案。但係如果係混合式咧，就容許佢可以期間收到一個低啲嘅價錢，但係咧如果贏咗之後咧，亦都可以攞到一個部分落嗰個財務利益咁樣嘅。咁呢個就係嗰3個唔同模式嘅例子啦。咁就呢個冷靜期嗰度咧，其實阿陳先生頭先已經講咗啦。其實我哋咧就選擇咗一個7日嘅最少嘅7日嘅冷靜期啦。咁所以咧就當事人咧係需要咧係可以咧係利用呢個書面嘅形式咧，係喺7日之內咧去終止嘅。個理念咧就係話咧有陣時可能一個當事人見到一位律師，咁個律師就同佢去介紹有關於呢啲咁嘅按條件收費啊、按損害賠償收費嘅嘢啦，咁可能佢即刻簽咗，咁但係咧佢亦都未有咁嘅機會。雖然佢知道有咁嘅權利，但係未有機會或者被說服啦，即刻簽咗，咁讓佢翻去諗清楚啦。好似某一啲嘅其他嘅合約啊、消費者合約，當然佢都俾佢時間去諗清楚，攞個法律意見，7日之內係可以用書面形式去到終止呢個咁嘅協議嘅，咁就對佢嚟講係一個保障。尤其是咧呢個係適用於一啲咧唔係話好清楚自己權利嘅仲裁當事人。咁不過我都想附加一句咧，其實仲裁嘅當事人咧，同一般訴訟嘅當事人咧係唔一樣嘅。因為點解咧？我頭先都講過少少，就係話仲裁嘅當事人咧係好需要有一份仲裁協議嘅。咁而呢啲仲裁協議簽署咧，通常咧就會係一啲嘅唔會係一啲用私人行事身份嘅個人。相反嚟講咧，會有一啲嘅係企業啦、公司啦或者法團啦，係會係因為一啲業務上嘅原因，同對方無論係本地或者係外地嘅跨境企業咧，係去簽署呢啲咁嘅協議。所以咧，一般嚟講咧，仲裁嘅當事人係會比較了解自己嘅權利嘅。而好多時候咧，佢哋甚至有自己嘅內務法務啦、律師啦，去幫佢哋去傾呢啲咁嘅協議。所以一般嚟講咧，呢樣嘢咧，我哋覺得唔係一個大問題。但係咧，由於咧第二啲地方都有呢個咁嘅冷靜期嘅要求咧，咁規定咧，咁所以我哋都係會有呢樣嘢。咁至於立法時間表，我相信呢個就係我哋當我哋頒咗呢個嘅最終報告之後啦，咁我相信政府會係盡快去跟進呢件事咁樣嘅。咁我睇下或者其他同事會唔會有其他嘅補充？唔該。
或者我補充一句啦，即係有啲評論咧就係話，咁呢個修例嘅建議咧係唔係令到律師嘅收費可以增加啊？所以我哋好強調呢個絕對唔啱嘅嚇。呢個我哋出發點主席已經講咗啦。第一呢一個同結果有關嘅收費安排。喺全世界嚟講咧，好多司法管轄區已經做咗㗎啦。其實大部分嘅國家已經實行咗呢一類型嘅收費嘅模式，除咗香港同新加坡。而主席亦講咗啦，新加坡其實亦都喺度諗住改例嘅。咁所以香港就會剩翻落嚟係最後一個主要嘅司法管轄區冇呢一種收費嘅安排。咁第一就係對香港嘅整體仲裁競爭力係非常重要嘅。第二，呢個並非係針對律師行業嘅優惠唔係俾律師去揾多啲錢嘅，目的係令到整體個服務水平提高，亦都能夠保障到公眾人士市民嘅權益嘅。咁所以頭先已經提到，我哋有好多建議嘅 safeguards 保障係擺咗落去嘅。咁所以係一個整體嘅考慮嚟嘅。
好，下一位優先。
你好啊，想問翻呢個 DBA 呢個50%其實係點樣釐定出嚟嘅呢？同埋都想問話喺咩情況之下呢？雙方係可以解除嗰個協議嘅呢？喺咩極端嘅情況下先可以嘅，或者係咩特定嘅情況下先得嘅呢？唔該。
兩個問題啊 ，Benny 一係答好冇？我
就第一個問題先，就關於呢個 DBA 即係話按損害賠償嘅呢個模式嘅收費嘅上限啦。就係其實咧，我哋咧喺當發個諮詢文件嗰陣時候咧，我哋初就參考咗唔同其他司法管轄區佢哋嘅嗰個上限咧。咁我哋咧當時咧就係問話大家可唔可以表達下個意見，睇下係30至50% 之間啦。咁但係咧，我哋收翻嚟嘅意見咧，其實大部分嘅意見咧，都係喺呢個咁嘅範圍裡面嘅。呢個50% 嘅其實呢一個咁嘅上限咧，其實咧我哋其實係跟英國而家嘅做法添嘅。英國而家咧佢哋當然啦，佢哋而家作出一個DBA 有關 DBA 嘅諮詢過程，咁但係呢個都進行咗一段時間。咁但係佢哋而家目前嘅做法咧，就係話將個上限咧係定喺嗰個嘅財務利益嘅50%。嗰度，咁我亦都要強調咧，呢一個咧只係一個上限嚟嘅啫，並不是代表咧一定係適用於所有嘅按損害賠償嘅收費協議上面嘅。咁所以咧呢個就要好特定嘅情況，就係睇下個案件本身啦，有幾複雜啦，嗰個風險係要幾多啦，咁各個唔同嘅因素啦，咁所以咧大家咧可以將呢個風險咧係去作為一個所謂嘅定價，咁而呢個50% 嘅上限咧，或者係唔同嘅嗰個嘅DBA 費用嗰個金額啦，咁其實呢個就會係某程度上反映嗰個嘅風險嘅所在嘅。咁但係咧，我哋覺得其實係有意見咧，係話咧係唔應該定任何上限嘅。咁但係個問題就係咧，我哋參考咗唔同司法管轄區，係的而且確係有呢個上限。咁我亦都係同意咧，係有個上限咧，係會起碼會減少一啲情況，就係話律師係過度收費或者過度補償。咁呢個無論係實際或者感覺上咧，我哋覺得係比較好啲嘅。咁所以咧，我哋就最後嘅最終建議咧，都係咧係想將呢個DBA 嘅設定上限咧，就定喺50%咁樣嚇。咁第二個問題就係關於話點樣解除協議呢樣嘢咧。嗱，喺解除協議嘅上面咧，即係其實好似任何嘅合約條款啦，其實都係由訂合約雙方可以去傾嘅。就呢個解除協議咧，我哋係有一個建議，就話喺嗰個附屬法例裏面咧，就會係寫清楚啦，就話咧喺嗰個協議上面一定要寫明喺乜嘢情況之下先可以解除。解除咗之後，嗰個律師可以收費，用咩模式去收費？呢一啲咧係全部都係要寫出嚟嘅。咁如果係要滿足晒呢啲條件咧，先至為一份有效嘅呢啲嘅收費協議。咁所以咧第一就係要受當事人雙方同意啦。咁如果你問我有啲咩嘅通常嘅情況係會咁樣，就可能係譬如一個當事人佢根本係好唔合作嘅同個律師。譬如你話個律師問佢話關於啲案件有啲咩文件係要提供出嚟，佢唔提供出嚟，咁佢收埋啲文件。咁嘅情況之下呢，咁律師根本冇辦法可以衡量到個案去點樣去恰當咁去進行啦，點樣去幫佢爭取個利益啦。喺咁嘅情況之下，根本律師如果再要求佢去承擔呢個風險呢，似乎呢喺某啲情況就真係唔係好公平嘅。咁所以呢個係其中一個例子，可以係話其實律師喺咁嘅情況都可能可以去終止呢個協議。當然客人亦都有第二啲嘅考慮嘅嚇，咁呢個係可以喺可以係非常之多嘅唔同嘅情況。所以呢個就係一個讓雙方係去討論咗，但係要清楚記錄內在嗰個協議上面呢，究竟係喺咩情況之下先可以終止咁樣落。
係因為RTHK 3。
Hi. First of all, I'd like to ask about your recommendation. What are the changes in circumstances that lead to, in the past, Singapore and Hong Kong have such a ban on fee structure related to the outcome of arbitration cases, and now both places you're recommending that we lift such a ban, and Singapore is planning to do so as well. Just can you explain the change in circumstances for such a recommendation? And can you also explain in layman's term how do lawyers, both lawyers and users, benefit from the lifting of such a ban? Because especially when potentially users, the clients, could be paying a higher fee when the cases are successful. And also, you explained the lawyers may bear risk in the first recommendation of this. Basically, can you explain the difference between a hybrid structure and also this first recommendation? I cannot remember the actual term. Let me just quickly go back to, excuse me, conditional fee agreement. Because the lawyer may also be charging a part of their hourly rate. So how is it different from the hybrid fee structure? Thank you.
I'll answer that question. I think in terms of the change in circumstances, bearing in mind that the reform is limited to arbitration and not all forms of contentious proceedings, because most other arbitration seats, important arbitration seats in the world, allow these types of fees. The sense is that clients, when they are agreeing contracts with their counterparts, as part of that contract, you agree an arbitration agreement, and that goes inside your contract. It's a provision in the contract where the parties agree to resolve their disputes through arbitration as opposed to through court proceedings. So arbitration is a consensual process and is increasingly popular in cross-border multi-jurisdictional disputes, and that's because of the ability and the ease of enforcing arbitration judgments across across borders. So arbitration is really the preferred method of resolving disputes between sophisticated multinational parties. And when they are looking at where to choose to seat that arbitration, clients are likely to want to seat their arbitrations where they have the most flexibility as to how they can structure fee arrangements with their lawyers. So the change in circumstances is the need to maintain Hong Kong's competitiveness and attractiveness as a seat for commercial international arbitration. If you are a businessman sitting in England and Wales and you are used to being able to choose, you can seat your arbitration in London, you can seat your arbitration in Paris, you can seat your arbitration in New York or Hong Kong or Singapore, and you are, as a lawyer, as a businessman, are used to being able to say to your lawyers, well, I want you to share some of the risk with me in whether I win or lose in a dispute, then that party is more likely than not to choose to seat their arbitration in a jurisdiction that permits them to have the greatest flexibility in the way that they can structure fee arrangements with their lawyers. So the change in circumstances is really responding to client demand and the need to enhance and really maintain Hong Kong, which is a very successful seat for arbitration, but to allow it to remain competitive. And the public in Hong Kong also have an interest in ensuring that there is access to justice and that the method of resolving disputes is fair and competitive with other jurisdictions. So that's really the change in circumstances, and you can see that Singapore has looked at it from the same perspective and sees the need to bring Singapore's legislation in an arbitration context up to speed with other jurisdictions that offer similar fees. In terms of the benefit, I think from a client's perspective, I mean, Hong Kong has a freedom of economy and the ability to have freedom of contract. Clients want to be able to choose how they structure their fee arrangements with their lawyers, and do they want their lawyers to share the risk, as I've said, in whether their case is successful. So clients increasingly are coming to us, as I sit in a law firm. Clients, are asking us all the time, can you do a success fee? Can I agree with you that I will pay you either a discounted fee or no fee at all, and then we will share the benefit if the matter is successful. So we are really responding to client demand. And also from a disputes community perspective in Hong Kong, if Hong Kong maintains its status as a leading arbitration seat and as a leading dispute centre, that benefits not only the legal profession and the barrister profession, but it also benefits the disputes community as a whole and all stakeholders that participate in the regime. So for example, if you have a 5-week arbitration that runs in Hong Kong, and before COVID, when people were travelling, then you would have teams of lawyers flying into Hong Kong, staying in Hong Kong. It benefits the economy, it benefits users, not just the people involved in the arbitration itself. And one of the interesting comments, and this came up in the reform in 2007, the concern that there is a conflict of interest between lawyer and client is really outdated. And Sir Rupert Jackson in the UK gives a very nice example. If you, as a lawyer, you might have charged your client 2 million Hong Kong dollars in fees, and the other side proposes a settlement that's a good settlement. As the position stands today, the lawyer really has no incentive to get the client to agree the settlement. The lawyer, if that case does not settle and the case runs for another 2 years, and the lawyer benefits because the lawyer gets paid another 2 years worth of fees. And imagine if 2 years later the client gets $10 more in the arbitration than it would have got through the settlement, but has paid another 2 million in fees to its lawyer. Or in the arbitration, the client gets a lower sum than the settlement. By aligning lawyer and client interests, the lawyer has what we call skin in the game. They are moving in the same direction, and that really, we think, there is no conflict of interest. The interests of lawyer and client are aligned, and that's for the benefit of the client as well. In terms of a hybrid DBA and the difference between a hybrid DBA and a CFA, a DBA really, as Dr. Lowe said, is where the lawyer takes a percentage of the financial benefit that the client obtains through the arbitration, whether that's through a settlement or through an arbitration award. So you as a client, let's say you have a claim against the respondent for 1 million Hong Kong dollars, and you win in the arbitration. In a normal DBA setting, the lawyer will receive no fee at all, but will receive a percentage of that $1 million damages award. In a hybrid situation, to allow the lawyer, as Dr. Lowe said, to have cash flow and liquidity, and that really, I think, assists smaller law firms, perhaps more than the larger law firms, but it allows smaller law firms to charge a discounted fee by reference to hourly rates or benchmark rates as the arbitration progresses. But then at the end of the arbitration, if the arbitration is successful, that fee will be offset against, then there'll be a DBA payment that goes to the lawyer as well. So that the lawyer will get a share of the success, and then in the arbitration, the fees that have been paid to the lawyer will be dealt with by the tribunal in terms of asking the losing party to bear some of the legal fees in the arbitration. So the legal fees gets dealt with in the normal way through the arbitration, but the lawyer also gets a DBA payment, which relates to the damages that the client is awarded in the arbitration. So that's really the key difference, is the DBA payment is the success that the lawyer obtains through the DBA regime, whereas under the CFA regime, the lawyer, for example, would say, if you are successful, I will charge you 70% of my hourly rate, but I will charge you 120% if I am successful. So there is an extra 50% on top, which is reference to the hourly rate that the lawyer charges. So it's really a way in which the lawyer is compensated that is different. The final point to make is the reason for recommending hybrid DBAs, and this is something that the UK, England and Wales is looking at and has also recommended, and the reform was expected to go through in 2020, but because of COVID it's been delayed. But there is a clear recommendation in England and Wales which follows other jurisdictions such as Canada to allow hybrid DBAs, and that's because with the ability to have third-party funding, in effect, lawyers and clients can have a form of a hybrid DBA by using a third-party funder, where the third-party funder pays parts of the lawyer's fees as the case progresses. And the beauty of a hybrid DBA, or the benefit of a hybrid DBA, is really it benefits the client, because the client not only has more flexibility, Does it do with third-party funding, hybrid DBA, or does it just have a hybrid DBA with its lawyer? And if, in fact, it benefits the client will likely pay lower fees overall if it just does a hybrid DBA with a lawyer. When you have a funder as well, then the cost to the client is likely to be greater. So allowing hybrid DBAs is really about allowing greater flexibility for the client, but also allowing the regime to benefit the disputes community in the same way.
TVB
想問翻清楚少少咧，而家我見嗰個報告書其實就係講話成功嘅結果咧係由個 client 同埋個律師簽訂協議嗰陣就去定明乜嘢係成功，即係你哋即係法改會就冇講清楚，即係點樣定義乜嘢叫成功啦。咁其實會唔會增加咗客人同埋律師之間嘅爭拗？即係可能客人佢即係其實有一個情況就係個被告係即係佢係一個被告，佢可能要幫佢減免一啲財務嘅損失咁樣啦。咁即係可能佢期望嘅一個金額同埋律師律師當初簽訂嗰個協議，可能佢本身唔係好清楚，即係可能佢可能期望去減一個大啲嘅金額，但係最後可能律師幫佢爭取到一個可能比較細嘅減免嘅金額，但係佢仍然可能觸發到嗰個 Dbas 嗰個即係要俾律師嗰個錢啦。咁其實會唔會增加咗雙方嘅爭拗咧？如果冇喺成功嘅結果呢個即係有一個官方嘅定義上面係啦，想問翻清楚少少呢個唔該。
你第一個觀察咧係對嘅，就係話咧，我哋係唔可能，亦都唔可能咧係話講到明話客人同埋律師之間要點樣去定義呢個為之成功啊？呢個係因為每個案件都有唔同，可能每一個案件啊，有啲情況就話我要攞晒100%我嘅申索額先叫成功，有啲就唔係，有啲覺得如果你攞到70%嘅個客人已經覺得係可以㗎啦。咁呢個咧就當每一個案件咧就大家要討論啦。咁另外一樣嘢咧就係話會唔會增加律師同埋客人嘅爭拗？咁呢個咧唔能夠排除係冇可能嘅。不過咧，首先第一，我哋個起點咧就應該考慮咩咧？就係呢一啲咁嘅按結果而定嘅收費模式咧，並唔係必須嘅，並唔係一個唯一嘅收費模式。其實咧，我哋咧，正如頭先主席所解釋咧，其實我哋點解會去建議修例去改革呢一方面嘅法律啊規定啊，就係去回應咧，其實回應一啲消費者嘅訴求同埋需求，同埋去保持同埋鞏固香港作為一個仲裁中心嘅一個競爭力。咁所以咧，其實客戶如果佢唔需要呢啲模式嘅，我哋冇得逼佢嘅。呢個係個起點先啦。咁我點解要有呢啲模式呢？就係正如頭先主席都講過啦，其實就係話有啲客人根本可能呢，如果冇呢啲模式呢，佢根本就負擔唔起個法律費用。根本如果有一個有基礎有理據嘅申索，根本就達至唔到，所以咧就攞唔到佢應得嘅公義。呢個係第一點。第二點嚟嘅話，就算係有一啲可能有啲企業根本佢係其實係有錢嘅，咁但係咧亦都唔代表咧每一個公司或者企業咧都係願意係花咁多錢喺度，因為可能佢哋有其他嘅priorities 啦，係想將呢一啲嘅法律或者唔確定嘅費用咧係喺佢哋嘅資產負債表裏面去排除，或者將佢減低。咁呢個亦都係回應市場需求嘅一個產物啦，或者我可以咁講。咁所以咧，如果客人係唔想要呢一樣嘢嘅話咧，根本我哋唔會逼到佢嘅。咁我哋咪按翻普通嘅基準模式去收費咯。呢個第一點啦。第二點就話好啦，如果個客人係想用呢一個咁嘅按結果嚟去定呢個收費模式咧，咁我哋覺得咧必須咧就係佢要清楚佢嘅權利喺邊度啦。咁所以正如咧主席喺開頭嘅開場白嗰陣時都講過啦，其實我哋其中一個好重要嘅保障措施咧，就係要求咧個律師係必須要向客人咧去解釋翻佢嘅權利可能有需要，甚至係你亦都可以去徵詢一個第三方嘅法律意見攞一個意見咧，就係話睇下究竟應唔應該呢一個案件適唔適合係用呢個模式處理啦，會唔會有其他更好嘅模式處理，或者等等諸如此類嘅事件啦。另外一樣嘢就係話唔係淨係局限於呢個模式之外嘅，就係話頭先你個問題其實就有少少就係話究竟個律師原本就定咗一個財 財務利益嘅百分比嘅收費嚇，咁但係最後尾咧佢只係爭取到一啲一個低啲嘅財務利益係咪幫個客人？咁但係呢一樣嘢咧就同咧呢個收費模式本身咧未必有一個直接嘅關係嘅。雖然佢喺呢個咁嘅環境度產生，呢個就係其實講緊究竟可能就係話個律師有冇盡佢嘅能力去到幫佢客人爭取利益。呢一個就唔係話收費定嗰個上限啊，或者嗰個叫做百分比啊嘅事嚟嘅。咁所以咧呢一樣嘢其實根本客人一路以嚟咧都可能會同個律師有爭拗，無論係按結果收費或者不按結果收費，都可能會有呢個爭拗。咁所以咧我哋就唔覺得呢一點咧本身係會係影響咗我哋呢一個按仲裁結果收費嘅呢啲協議嘅一個可行性啊，或者一個應唔應該即係加入呢一個咁嘅選擇俾消費者去選擇嘅做法咯嚇。希望得到你問題。
我補充一句啦，即係我哋而家建議嘅呢3類嘅收費協議咧，咁佢都係客戶與以律師為例啦嚇，以律師事務所嘅一個收費協議嚟嘅。咁個律師嘅表現咧係受到我哋律師會非常嚴格嘅呢一個專業水平嘅規定嘅。咁所以如果客戶與律師事務所之間有任何嘅爭議咧，其實都可以根據既定律師會嘅機制去解決佢哋嘅問題嘅。咁譬如如果律師表現係不符合水平嘅話咧，香港律師會係有套機制去制裁呢一類嘅不違規嘅律師嘅。
仲有冇其他嘅問題？如果大家都冇其他問題嘅話呢，我哋今日記者會呢就喺呢一度告一段落啦。多謝大家嚟到我哋嘅法改會嘅記者會。